on the issue of challenging the juror in regards to the issues of the verdict form, conversations, or jurors that have come forth in the Karen Read trial, 4 of them now. I know one of them went directly to the defense attorney. 2 of them contacted the attorney via an intermediary. And I'm not sure on the 4th one how the 4th one contacted, but there have been 4 jurors come forward. And the issue was that they were confused as far as there was an understanding that they had an expectation that they would have come back with an instruction how to, since they were deadlocked on one issue, how to give the instruction on the remaining charges, the ones that they had come to an agreement that they were acquitted. And I shared in another video the specific instructions that the judge read was that on count 2, they were to start at the highest charge and then find whether they were guilty or not, and then work their way down through the lesser offenses in descending order. So that means if they were, say, on the second charge of count 2 in the indictment, they would have already come to an agreement of an acquittal on one of the charges. Now, they may have been a mixture of one thinks they're guilty of one charge in count 2 and the other one may think they're guilty of the other, or not at all. But they wouldn't have gotten to count 2 without having already acquitted her of second-degree murder. So there was also some allegation on whether or not that they were able to communicate. It's unknown at this time whether or not the jury foreperson presented to the judge, when that's his job, was to present questions that the other jurors had. So there was definitely some questions. So in the instruction argument back when the judge snapped at Karen Read and they were arguing over the instructions in the verdict form, Jackson, and I share this in video, he specifically asked the judge on that charge or that count to state whether, or to put on the verdict form that to say specifically that the defendant is found not guilty as charged or of any lesser offenses. So that was a problem, because for each and every offense that they're charged with that requires a guilty or non-guilty, there should be a guilty or non-guilty box for each and every one. So this is Rule 606 that I'm showing you. This is Federal Rules of Civil Procedure. And as far as I can tell, the Massachusetts states have adopted the Federal Rules of Evidence. It's up to the states whether or not they adopt them. And I went through some of their criminal evidence rules, and they make reference to the Federal Rules of Civil Procedure, so I'm not sure at what extent it appears that they have adopted Federal Rules of Civil Procedure, Criminal Procedure, excuse me. So Rule 606, this is about when they can inquire to a juror, because I've heard people in the legal arguments about you can't go in there, you can't bring jurors in, we don't go back in there, do all that post-trial. Okay, well, anywho's, here's an exception on, this is Rule 606B, and the exceptions on bringing a jury in to, like if they do what they've asked is not just a motion to dismiss, but at the very least, they said as an alternative, to hold an evidentiary hearing so that they can inquire that did the jury foreperson not bring, like actually they didn't ask for the jury foreperson to be questioned, because if there was specific questions of the jury, it was the jury foreperson's job to present that to judge. And the judge is the one who said that she's not going to allow them to read the communications. They weren't allowed to review it. She just read it in the court, which higher courts, I've shared with cases that found that that's a no-no. But anyway, so the exceptions are, if they were to have, now this is specifically about an inquiry into the validity of a verdict or an indictment. And one of the things that they do allow exception for, to drag them in there, is a mistake was made in entering the verdict on the verdict form. So if they had a box or anything that was confusing and they wanted to communicate to the judge that they, if they wanted to communicate to the judge about making sure, to let the judge know that she was in fact acquitted on specific charges. And for whatever reason, the verdict form was confusing because there was some statements that they did make comments about the verdict form. And so it's the jury foreperson's job. So I think that an evidentiary hearing is definitely going to be allowed, should be allowed, and should happen. And I think they would have, pretty strong appeal if they don't allow it. But anyways, I just wanted to share this. This is Rule 6, Federal Rule. No, this is Federal Rule. Okay, I'm talking about jury. And technically, it's juror's competency as a witness, and saying you're not allowed to have, jury may not testify as a witness before the other jurors of the trial. If a juror is called to testify, the court must give the party an opportunity to object outside the jury's presence, which is what they're doing motions currently. I don't know that I've read his motion to dismiss and his alternative request for evidentiary hearing. I don't see him quoting this. So I don't know Massachusetts law other than what I can look. And I did look in, and I think that they have adopted the federal rules. It appears they have. But, anywho's. So, and then, yeah. So I think that there was definitely a problem. If you remember the Kyle Rittenhouse, I'm just going to make it a comparison as far as Kyle Rittenhouse, when he was acquitted, they read each and every charge. And that's the way most trials go. On this count, do you find him guilty or not guilty? And then they read, they read not guilty. But they go through each and every one. Each and every one. And so they don't just say, is the defendant, when there's 4 charges that you can choose from, is the defendant guilty or not guilty? Say not guilty. They read each count. As you go back and look at Kyle Rittenhouse verdict, when he was being read his acquittal, basically. They read every single count that they charged him with, one by one. So there was a guilty or not guilty for every single count. And that's how it should be. That's just reasonable. So, you don't have issues you got going on right now. But anyways, I just wanted to share this.